Alrighty, y'all. This is We the People News one more time. So this video is without prejudice and without recourse. I'm not waiving none of my rights whatsoever, people. I never just look straight forward. I always look around me to be able to protect myself and my family by any means necessary. Yup. Okay, I'm not an attorney. I will not give legal advice. I will give you my opinion only. Do not take it as legal advice. Why? Because I'm not an attorney. That's why. So, came across this video. Now, I've seen this YouTube channel a couple of times, and mostly it's about jury notification, which we have not spoken a lot of for a while now. Alright? Jury notification is a tricky deal. It's got to be within some type of guidelines, right? And most of the time the juries had to look at it. Do I want to be charged for this illegal deal that's happened? Should I be charged by wearing a blue shirt on a Monday because the city said it's illegal? Right? And then you go to court. Jury notification will say, no, that's a stupid law, that's unconstitutional, and that should be null and void. Alright? Anyway, let's proceed forward on this. I have not watched the full details of it, but because I like the lady, and apparently there's a couple of attorneys on there, we'll see what happens.
I have a couple of questions that were quite popular, and one that I want to cover that I didn't get to in my portion. I'll start with that one. To say the least, the situation for speedy trials is abysmal, with most courts around the country having 12 to 16 months out of the out of the entire pandemic thus far be downtime with no jury trials. So for Clark and Catherine, I am wondering, what do you think is an actual reasonable time frame for speedy trials? And you might want to talk about felony versus misdemeanor and detained versus not detained pending trial. And why are those numbers not firm? Why is it that the government can just give itself pass after pass after pass? We'll start with Clark and then go to Catherine.
Yeah, so the Constitution guarantees the right to a public and speedy trial. And like so many terms in the Constitution, speedy is not defined, but we look to background principles and historical practice to try to get a sense of what's reasonable. The Federal Speedy Trial Act provides that the government is supposed to be able to bring a case, is supposed to not be able to, has an obligation to bring a case to trial within at least days. Obtaining indictment. So the government's really not supposed to indict a defendant until they're basically ready to try the case. The problem is in, and not surprisingly, all of the ways that the judiciary has come up with to enable the government to evade its speedy trial obligations. So there's both statutory obligations. There is a statute at the federal level and many states that sort of quantifies the amount of time the government has, but then there's this constitutional provision that also requires a speedy trial. But again, the real problem here is the creativity of the judiciary, which, as most of you probably already know, is disproportionately composed of former prosecutors, many of whom have sort of, evolved this mindset. And it's just very easy for the government to come up with excuses for extending the amount of time. And Catherine, I'm sure, can get into the details of that. But there are just lots of ways that the government can essentially get a free pass to extend and frankly evade its Speedy Trial Act obligations. And many prosecutors are extraordinarily adept at invoking and deploying those exceptions. So both the judiciary and the prosecution are, I would say, equally at fault for the fact that the speedy trial requirements are not, as robust as they ought to be.
Catherine, would you like to weigh in on that?
Okay, I'm going to pause there for a second. Yes, this is true. It's not really defined. However, we also, by just common sense, sitting in jail for 3 years or 10 years, I doubt there's been anything about 10 years, but a couple of years, even a year, y'all, is ridiculous. Okay? Without having a court date, because you've been sentenced already. All right? You are sitting in jail without a bond due to some officer or pre-notion of some type of warrant, and yet you have not been convicted. So therefore, while you're sitting in that jail, you in fact have been lack of due process and convicted without even seeing a judge. That's just my opinion. I am not giving legal advice. Why? Because I'm not an attorney. Okay? But it stands to reason, if I'm in jail and I did not really actually have the right to due process, and I've been sitting there for a year to wait to be in jail, I've been convicted. Alright? The issue is not hard. It's not complicated, y'all. They just make it complicated on purpose. When they are backed up like they are, the prosecutor could go through there and go through the list and find out what the most minor cases are involved in this, and actually go ahead and do acquittal, which is my first option, is acquittal. Always acquittal. Or do a dismiss. Okay? But you also want that dismiss to be with prejudice, but minimum just dismissal without prejudice. Okay? But there is the 3 options right there just to free up the courts. So a couple of years, a year long is ridiculous. It's ridiculous. And it's the prosecutor that is part of the cause and effect of this stupidity. Okay? And I would argue the fact that, you need to call your prosecutor and say, hey, if we're that fool, let's clean house and restart all over, basically. Find out to what the lowest deal is. Obviously, if there's 1,400 murder deals, that may take a while because you just can't do it. But prosecutors may have to actually get off their butts and really say, okay, how much evidence do I have to really proceed forward on this? Okay, I'm limited on evidence. We may have to drop it. And they can do a dismissal without prejudice, which means they can bring it back up again. Okay? But if you, and I'm talking about everybody out there, try to get a dismissal at the minimum with prejudice, y'all. But ask for acquittal. Okay? I don't care if it's tickets all the way up to murder. Alright? Sorry. Proceed forward.
The speedy trial issue is a complicated one because, we do here in Georgia have a statutory speedy trial right, which is where if you formally demand a speedy trial, they are required to try you within that next term of court or the term immediately after. For a capital case, anything where you could potentially get the death penalty, even if it's not on the table, they do get an extra term of court. But of course, in some places, a term of court is 6 months. In some places, a term of court is 2 months. And so really, I think for incarcerated clients, that is the biggest priority right now. And the right to a speedy trial has been denied for a long time for these folks, even well before the pandemic. But of course, the backlog has just made it even more of a disaster. For the cases that I mentioned trying last year, 2 of the individuals had been in custody for almost 3 years pending trial. They had been held without bond, and they were very serious charges, of course, but that's really, to me, really at the very outside edge of what should even be constitutionally permissible. However, I also have to acknowledge that, prosecutors and judges are certainly to blame for a lot of it, and certainly whenever I see a trial calendar that has a whole bunch of cases on it with victimless crimes, that's clogging up the calendar and keeping the real crimes from being tried, the real things where the community does have an interest in having it tried. But I have to acknowledge that as a defense attorney who represents people all over the state, it is sometimes my schedule and my conflicts that prohibit a trial from being tried at a given time. And so, I have to acknowledge it's not always the prosecutors. Sometimes it is the schedule of a defense attorney. And in that case, you really just have to prioritize the incarcerated folks over others right now.
One question that I kind of consolidated a bunch of people's questions was about something else we haven't covered. A number of people had questions about cases that just don't get a trial and how we can fix that. So, for instance, the government has largely or completely eliminated the option of a jury in asset forfeiture cases. Immigration courts come to mind. David specifically asked about family law type cases such as termination of parental rights, child custody, etc., and astutely points out that these are types of issues that probably many more people are affected by the lack of jury on than, say, criminal cases. What can we do about that? Are there any prospects for getting juries back on those types of cases?
Well, I think you got to pick your battles, to be honest. Judges tend to be extremely hostile to jury trials. I mean, they know they're not supposed to act like it, and they're supposed to say they're not, but they are. And they're time-consuming. Picking a jury and running a jury trial is a complex and time-consuming process. And part of the problem here is the way that judges have interpreted various constitutional guarantees. So, for example, the Seventh Amendment guarantees the right to a jury trial in civil cases, but the judiciary has interpreted that so it doesn't apply.
Number one, the judge should interpret it. What was the intent? Judges have a tendency to bypass the intent and go by interpretations.
To things like an administrative proceeding or a trial or a lawsuit where the the plaintiff is seeking purely injunctive relief. In other words, the Seventh Amendment has been interpreted only to apply to a very special subset of litigation involving civil.
Not been interpreted. The Seventh Amendment actually has an intent if you read it.
Claims. Involving money damages. And again, I know it's sort of like, I sound like a broken record, but the judiciary has been extraordinarily creative in limiting the scope of the right to a jury trial. And I personally am not so sure that and you have to, again, pick your battles. And if you're going to put a whole bunch of effort into saying, hey, there should be a jury trial for, family law cases, for example, which maybe there should be, then that's going to be time that you didn't spend advocating for jury trials in criminal cases, where I think the need is more acute. That's easy for me to say. I understand that. I've not been involved in a family law case personally, but you have to ask yourself every single time you wake up, what is the most important thing that I can fight for today?
Mr. Attorney, the Constitution. You just talked about the Seventh Amendment. Did you or did you not?
Our time is limited and the bandwidth of policymakers is limited, and if you spend that time or that bandwidth on something that's a lower priority, then a higher priority is necessarily going to go unaddressed. I know it's not easy, but you have to prioritize.
And Catherine, any thoughts on that?
I do think that the constitutional right to trial by jury has just been eviscerated in all of these fields, which, as we mentioned, family law, immigration, all these areas that are legitimate controversies that have.
Now listen to these people. They're not saying trial jury. They keep saying trial by jury, right? But when you go into court, they say jury trial. You've been. They'll send you a letter saying you've been selected for jury trial. Trial by jury and jury trial, and it's two different things. It's common law, corporate law.
civil and criminal components. You have property at risk, you have liberty at risk, you have lives at risk when you are talking about something like the custody of children. And so some of the folks may remember I had a case a few years ago about a family that was giving their son cannabis to treat his seizures. And, you know, the fight over the criminal side of that was a small fraction of the case. You know, we were actually able to beat the reckless conduct charges and get them dismissed, but it was the work that, you know, particularly Macon attorney Lauren Deal did on the family law side of the case where the real challenge was. And so I do think we need to keep that in mind, that jury trials, you know, we have normalized a situation in which jury trials are denied for a lot of legitimate controversies, but I also understand Clark's point. You know, at this point, we do not have a right to jury trial in the federal courts for misdemeanors. That is ludicrous to me, that they can stack up 6-month charges on you and force you into a bench trial. And I just had a judge last week sort of go off on a rant threatening that, you know, maybe this is going to happen here in Georgia. They're going to, you know, take the legislature and all their wisdom will take away the right to misdemeanor jury trials. And it was hard to tell whether the judge actually thought that was a good idea or not. But really, I agree, we need jury trials everywhere we can get them, and that right has been systematically denied. So I wonder what this conversation would have looked like 100 years ago, you know, where I think perhaps the right to trial by jury was taken more for granted and then has been administrative.
100 years ago, sorry to say, there'd be pitchforks. Just saying.
And bureaucratically curtailed systematically in a way that we have normalized. Well, you know, of course it's going to be a guy in a room making that decision.
Mike, I have a couple questions from you from Jeffrey. Jeffrey would like to know, has pre-conviction asset forfeiture been challenged on constitutional grounds, and who would have standing to bring such a case?
That's a good question that I don't know the answer to. So I don't know.
I do. I've litigated these cases. The short answer is no, and that's not a plausible challenge. What has been challenged is the government's failure to provide a prompt pre-seizure or post-seizure hearing. The Supreme Court has said that when the government takes your property, the default is that they are supposed to provide a pre-seizure hearing if possible. That means that you get to go in front of a neutral judge or other magistrate and not get a final ruling on the merits, but just sort of have a chance to, you know, come in and say, look, they've got the wrong person. I am John Smith, but I have a different middle name, so that I'm not the right person. One of the things, I won't get into this too much, but it's incredibly frustrating as somebody who's litigated these forfeiture cases and had to listen to prosecutors tell audiences, oh, you know, if there were any problem with this, the Supreme Court would tell us. That is absolutely false. It is a malicious lie, and they should know that it is, and here's why. The government actually, in many settings, particularly in forfeiture, actually has the ability to frustrate judicial review, to prevent the judiciary from declaring that a particular practice, like civil forfeiture as a whole, or even a particular practice, a particular kind of civil forfeiture, is unconstitutional. How can they do it? And they do this all the time, by the way. What they do is they will fight you right up until the point where it looks like you might be about to win. In other words, you're about to get a favorable court ruling that will not only result in the return of your property, but could also result in favorable precedent. Maybe that particular approach to forfeiture being struck down. And guess what the government not only can do, but I've seen them do repeatedly. They moot the case. That means they give back the property. So now you've got your car back or you've got your cash back. And the judge then says, oh, well, there's nothing to fight about anymore. This is a moot case. I'm not here to issue an advisory opinion. The case is over. And you don't get a ruling on the merits of that practice. And that actually happened in a Supreme Court case where the city of Chicago was doing these drug arrests where they would go in, they would do the drug bust, and they would pretty much grab any car that they could see on the block where the thing happened, and you wouldn't get a hearing for over a year. That ended up getting struck down by the Seventh Circuit Court of Appeals. It went up to the Supreme Court. The city could see the handwriting on the wall. They knew they were going to lose that case and potentially set bad precedent. You want to guess what they did? They gave everybody back their cars. And the Supreme Court said, oh, well, looks like we don't have a case here. So I think there's a lot of unconstitutional practices in civil forfeiture. But what's really hard is getting courts to rule on them because the government is so cynical and so unwilling to test the legality of what they do on a daily basis, and they will turn tail and run from their own practices by mooting cases when it looks like they're about to lose. And it is a despicable and cynical act on the part of government, and I've seen it over and over again.
Well,
I 100% agree. That's exactly what the government does, and that's exactly what the states also do. That's the reason why you have people saying it's settled out of court all the time, because it's starting to look like it's a lose situation and they don't want to proceed forward and they want to settle. Yeah, which is egregious.
now thoroughly infuriated. Thought I started out that way, learned I wasn't. But always learn something new that is horrifying in a new and exciting way. I still have more questions, but we are out of time. So what I think I will do is try and answer some of these afterward and put a page up on the FIJA website with some of these answers. Apologies to those whose questions we didn't get to. Perhaps next year we will make this a little bit longer event because there are some great questions this year. I want to let everyone know, please visit. You'll find either on Facebook in the comments section or on Zoom in the chat links. Particularly, I'd like to point out we have a page of resources and references related to today's topics on the FIJA website. From what I've heard here, I have a couple more that I'm going to add for you in the next day or so. Also, if you visit fija.org/next, you will find out how to participate in our Monday evening 15-minute update sessions, 15 minutes with FIJA, and our upcoming webinar, Punishment Without Trial, a conversation with Professor Carissa Byrne-Hessick. She is the author of Punishment Without Trial, and we will be discussing her book, specifically focusing on jury nullification, which she gets into just a little bit, but I don't think is probably something that's been covered very, very much in her interviews and webinars thus far. Thank you so much to my guests. Thank you, Catherine. Thank you, Clark. Thank you, Mike, for joining me again this year. I have learned...
All right, y'all. This is Diesel We the People News. There you go. All right. Till next time. Bye.